Hernandez, the co-chair to the small and solo firm section here at the HMBA, and we have this brand new partnership with Berkeley Select. And so we wanted to talk a little today about guarding your practice and understanding malpractice insurance, generally speaking. And so um, we hope that you all find this insightful. And to kick us off, I'm going to pass it over to Al.
Good afternoon. First and foremost, I'd like to thank the HNBA for welcoming Berkeley Select as a partner. We're very excited about this relationship with them and very proud to be a member participant with the HNBA this year. I'd like to introduce my esteemed and distinguished panel this afternoon. First, April Toy. She's a partner at Hinshaw, a graduate of Marquette University Law School, and a resident of Milwaukee. She has years of commercial civil litigation experience and has successfully tried cases to verdict and defends lawyers against malpractice. So you definitely have an expert on this call today. She's also a partner of ours at Berkeley Select for our risk management program that we provide to our insureds through Hinshaw. Daniel Hernandez is a successful entrepreneur and founder and CEO of Next Level Law in Chicago. He's also a graduate of UIC Law, which is my alma mater. Daniel practices family law, and he specializes in divorce and custody matters and has a compassion and focus on problem solving. And welcome to everybody out there who's joined us this afternoon. If you want to put the slides up. There we go. We could go to the agenda. So today we're going to be talking about guarding your practice, but that also includes, understanding some of the common coverages and exclusions within your lawyer's professional liability policy, as well as going through some of the things that you should be aware of, or at least from an underwriting perspective at a carrier that you should be aware of when applying for insurance. Then we're going to discuss some claims that are made against lawyers, discuss risk management services, and then I'm going to briefly conclude with who WRB is, who Berkeley Select is, and what our appetite is for insuring lawyers. So you could turn to the next one. So what does your policy cover? So Daniel, when you started your firm and you were looking to protect your practice, what were some of the things that you wanted to make sure you had protection so that you could run your business effectively?
Yeah, I'll always say I started my practice a year after graduating from law school with very little experience. And so I felt at the time like anything I did caused this extreme anxiety, right? Did I do it right? What's going on? What if I messed up? And so I really was trying to fill in that gap. The what if I mess up? What will happen? And so I can't tell you that I was looking for something in particular, because I'll be honest, I didn't know what I was looking for, but I know that I wanted the anxiety in me to be calm, to know that if I do make a mistake, because we're all human, and we're probably going to make a mistake at some point, that I'll be covered, right? I always say I don't think any lawyer leads with, "Hey, today I'm going to commit malpractice," but I certainly believe that we all go out there, want to do a great job, but sometimes a filing deadline is missed, right? And that could cause something bad to happen to our clients, right? Maybe you get sick and that's why things were missed, right? And we all need to cover ourselves in that way. But essentially, I wanted the negligence piece. Like, what if I was negligent one day? How would I be able to survive a claim against me?
Yeah, I think one of the keys to understanding what's covered is we want to make sure that any mistake that you make throughout your practice is covered. And when I say covered, that means that there's money allocated to pay a plaintiff who would be suing you. as well as to pay defense panel to protect you and defend you if the matter was litigated, and to settle on your behalf. Uh, typically, what you would expect to have covered are, obviously errors and omissions, mistakes that you make in practice, but also a lot of attorneys get into trouble by clients filing disciplinary matters against them. And from what we see on the carrier side, most disciplinary matters are usually resolved favorably for the lawyers. Disciplinary matters usually are triggered by someone who might be a little bit disgruntled, a client that might be unhappy. Uh, some of them are very fabricated, and you want to make sure that you have a policy there that's going to protect you and have attorneys fight for you. Uh, is there anything that I'm missing, April, in the defense of these matters, that you see, especially the frivolous matters?
Right. I mean, I think one of the things we see so often are disappointed expectations as opposed to actual um, professional shortcomings. But I think you covered that all very, very well. So when we're talking about frivolous matters, we're really talking about somebody who is just unhappy with the outcome. Of course, all lawyers know we cannot guarantee an outcome, but just because the outcome wasn't what you wanted does not mean that what the client wanted does not mean that the lawyer has done something wrong.
Absolutely. Why don't we flip to the
Well,
next
wow.
so we
I
can,
would just
oh,
add, I just wanted to add one piece. It's really interesting that you bring up the disciplinary matters piece, because that's something at first I never thought about, right? I never thought like, oh, what if someone files an ARDC complaint? I actually thought that that was not a common thing. And come to find out, it's a great perk. I remember when I was being sold my malpractice insurance, they said, yeah, when you get an ARDC complaint, you'll have us, you'll have an attorney. And I was like, oh, I'm never going to get one of those. And yeah, as the conversation goes on, we'll learn more about it, but it's a great piece to have.
Right. And so
absolutely.
ARDC is similar to like a bar complaint. Different states have different names for it. So just to clarify what Daniel was saying.
So next, I'll run through what are things that are typically covered under a lawyer's professional liability policy and things that are usually not covered. So this is something, if you have your policies handy, maybe when you get off this webinar today, you can kind of go through them just to make sure you have whatever the basic expectations for coverage, make sure that they're in your policy. So who is covered, who isn't insured under the policy? So this is a definition section for most policies, and obviously it includes lawyers, but it also includes of counsels, any independent contractors that you would hire, corporate entities. So if you're a PC, if you're an LLC, you want to make sure that that corporate entity is covered as well. Current and former employees. So if you have a malpractice policy and someone leaves your firm and they made a mistake before they left, you still have coverage for them under your policy, even though they're no longer with your firm. And in the unfortunate event, if an attorney passes, especially if it's a solo attorney, the estate of the attorney is covered. So if the estate is sued, there is coverage for that. For legal services, it can be simply defined as, those services performed by a lawyer in a lawyer-client relationship, but it really goes beyond that, because there are services that lawyers provide, such as a notary. Pro bono services would be covered. In your capacity as a trustee or other fiduciary, a guardian, an executor, those are covered, and those would be considered legal services. So you want to make sure that your policy has a very broad definition of legal services so that you're protected. This concept of duty to defend, we talked about on the previous slide. When a claim comes in, obviously there's a limit there that would pay for damages, that would pay for the mistake that you made and any resulting damages. But you also want to be able to be defended, because we talked about disciplinary matters being frivolous. There are a lot of law firms that get sued and they're frivolous lawsuits. So you want to make sure that you have a policy that does have claim expenses. Sometimes they don't erode your limit. Sometimes they do erode your limit. That's something you might want to, look at your declarations page to make sure you have that coverage. Another thing to look at, innocent insured protection, if you're a partner in a law firm and your partner goes rogue on you and you don't really know that your partner is doing some bad things, your policy should protect you as an innocent insured who did not participate in those things. We're going to talk about prior acts in a little bit, but I wanted to also say what is not covered. So you shouldn't have an expectation of coverage for the items that are listed on the right-hand side. So criminal acts, those are not covered. An example of that would be conversion of funds. So if you are stealing money from your client, that is not a mistake. That is considered an intentional act, not be covered. Contractual liability is something that also is not covered. We don't want to insure against guarantees that you make or contracts that you make with potential clients about your liability. We basically cover legal liability. So, unless that contractual liability would actually be legal liability in a particular state, we don't want contractual liability picked up under the coverage. Outside interests, I always like to tell attorneys, it's best not to have conflicts of interests. So there are attorneys that sometimes sit on boards, and a lot of them do that for charity organizations. And I think that's wonderful. And I would encourage that, but sometimes they're asked to do that for clients. And that's a slippery slope for attorneys to get into. I would try to avoid outside interests if possible, because you can only really have one master, and that's your client. Having multiple masters, and if you're trying to make a profit for an organization that you either own or have a board seat on, it's difficult. And then prior knowledge is another issue. It's a tougher issue because these policies work in continuum, and these are claims made and reported policies. You don't really want to be switching carriers or applying for insurance if you know about something bad that's about to happen, and that's what prior knowledge is. I'll explain that in a little bit more detail when we get through the slides. But April and Daniel, am I missing anything else with expectations of coverage and what are typically covered under your policies and not covered?
So I actually wanted to ask you a couple of questions to just further explain some of the key concepts. Number one, an eroding versus a non-eroding policy. What is that? What does that mean, in terms of attorney fees, for instance, and how does that come to play out so that our people can know what to look for when they're purchasing a policy?
That's a great question. So claims expenses outside the limit, it's a nice feature to have claims expenses that do not erode the limit of liability that would be reserved to pay damages. So some policies, you have one limit of liability and it's applicable to claim expenses, meaning those would go towards legal fees and hiring an attorney to defend you in the case of a malpractice action. And they would reduce the amount that would be left to pay for the amount of a claim, to pay the actual damages, to make the plaintiff whole. So usually that's typically found on a declarations page. So you may want to look at your declarations page. Most times claims expenses outside the limit are offered on an optional basis or a sublimited basis. They do cost a little bit more money. Those policies do have an additional fee incurred because you are getting a little bit more coverage. So I would look for that just to make sure that your claims expenses, ideally, you have additional expense limit allocated to pay for the attorneys, and you would be able to have some limit reserved or specifically allocated for damages to pay the plaintiff.
Right. So what you don't want to see is that, as you're litigating a case, the attorney's doing a great job, but they have to do a lot of discovery, et cetera. And what that means is, depending on the type of coverage you have, that might erode some of the money that's available to pay to the plaintiff to resolve the case. Did I explain that in a fairly
Perfect? Yep.
Yeah. So that's one of the big things. And then the contractual liability, obviously, lawyers, we have a relationship with the clients in both contract and tort in many states. And so it's not that, the contractual claims wouldn't be covered. Really what they're looking at is, did you promise by contract to do something outside of that outside of that attorney-client agreement. So for instance, indemnity, things like that.
Yeah, it's one of those situations where if you, you're a real estate attorney and you're representing a large developer and they're looking to purchase a large parcel of land to build an Amazon warehouse, and your contractor with your contract with the developer says that if this deal does not go through, you, my attorney, will be liable for 100% of everything. That's a good example of, you're providing more than you should under a legal doctrine.
Okay, I think we're ready to move on to the next one.
Right.
Anything, Daniel?
So this is kind of an interesting concept, and I think if you click again, there'll be some bullet points that go to the right. You could just put them all up there. So if you're a first-time purchaser of insurance to protect your practice, you would be purchasing what's called a retro date inception policy. That means you do not have prior acts coverage. Remember I said earlier that these policies run on a continuum. What that means is for every year in practice, you have coverage under your current policy, meaning the policy that you currently have would look back to when you first started your insurance. So a retro date insurance policy, those are good for attorneys who are just first-time purchasers. They might be starting their own practice. Like Daniel said, when he was, forming his business, he didn't have anything in the past that he wanted coverage for. You want to make sure that once you have a policy in place, because these are all considered claims made and reported policies, that you maintain that policy so that you do not lose your prior acts coverage. That's very important because statute of limitations, in the case of contracts, for instance, they could be 5 to 10 years. So if you have a retro inception policy that starts today, July 25th, but you performed a contract, you entered into a contract, and you had some liability from that exposure in 2023, that might not be covered under your policy. So the key is not to scare anybody, but just to make sure that whenever you have prior acts coverage, you maintain it. And you only maintain that by continuing to insure your policy. It's very important. So that's something that, if you're working with a good broker, or if you're doing this on your own, that you maintain your coverage for your practice, because you want to make sure that on a continuum basis, you have coverage going back to either when you first opened your practice or you first started practicing law.
Well, before you move on, a question for you. How does that affect someone when they change from one provider to another? Does it affect someone based on premiums and stuff? That's always been a burning question I've had ever since I learned about this retro date inception.
That's a great question. There are really two pitfalls you can get into when you're moving from carrier to carrier. The first one is making sure you preserve your prior acts coverage. So terms that you would get from another carrier will specifically state what your prior acts date is. That's going to actually be a term of the quote that you receive. And if you don't see that there, make sure that if you look at your expiring policy, you tell that broker or retail agent or carrier that you're working with that you want to maintain that coverage. Now, you do pay for it. There's a charge for it on a continuing basis. It usually levels off after about 4 or 5 years, meaning the cost to maintain it doesn't really increase. It usually is more expensive, the first, second, third, fourth, or fifth year. So that's kind of how that works. But that's one of those things when you're receiving a quote, you want to make sure that your retroactive date or your prior acts date matches what your current coverage is. That's something you need to be an advocate for yourself about. The second thing when applying for insurance, and we'll discuss this, but this is a big thing for carriers, and this is a pitfall, is there's going to be a question on the application that's going to ask you if you are aware of something. Not necessarily a claim, but are you aware of something that could lead to a claim, these potential claims or incidents? You have to really honestly and truthfully answer those questions because the carriers rely on that information. So I don't want to jump the gun. We're going to get into that in a little bit. You could flip to the next slide, please. So when you're filling out the application, the things to consider. So all applications should be signed by a principal within the firm. And those are the people who have the most intimate knowledge about the practice. Remember, when you're filling out an application, this is an application that's going to become a part of your contract with the insurance carrier. It's completed by every member of the firm, and the person who's signing it is really the proxy for everyone in that firm who's seeking coverage. So if insurance companies rely on all the statements, obviously be as truthful as you possibly can, avoid material misrepresentations. If you're doing a certain practice area, just disclose that. Most practice areas are covered by most insurance companies. And what we like to see is, somebody on the underwriting side, somebody who has knowledge and experience doing those practice areas. That's what we look for. So just make sure that these are very true and accurate. If you're working with a broker, I would not necessarily want to have them pre-fill anything for you. I would want to be the one who's filling those answers to all the questions. And when we talk about prior knowledge and we talk about the pitfalls there, if you're moving from one carrier to another and you have a claim that you have not reported to your prior carrier, you shouldn't try to save it and put it in your back pocket and report it to the carrier you're moving to. Just don't do that. You should disclose it to your current carrier before you switch carriers or tell your agent about it. Because we ask about those questions. Those are very important questions that carriers rely upon. And I don't want to see anybody get into a situation where they switch carriers and they have a claim that's not covered because they should have disclosed it under their prior policy and they should have disclosed it on the application for insurance with their new carrier. So most applications also have fraud disclosures. I know there are certain states that are really aggressive about pursuing insurance fraud, such as New Jersey. So if someone does make a false statement on an insurance application, I've seen the state of New Jersey go after that particular applicant. So I don't want anyone to be in those types of situations. April, is there any other risk management, regarding material misrepresentations and filling out the application that I missed?
No, but if I could just add a couple of points, this idea of making sure that you report your claim. It's not that, anyone's trying to find a way out of not paying a claim. It's just that, when the insurance company is agreeing to take on you as a risk, they have to know what's under the hood. And they will rate their premium on it. And so if if you don't disclose that there's this potential claim out there, then down the road it could become a problem. And in fact, I always say when it comes to claims and in reporting these to your insurance carrier, whether it's on the application about a potential claim or if a claim arises after the policy has been issued, is report claims often and timely.
Okay, that's great advice. So your application question, the one that we've been discussing, and I'm being a little bit more tedious on this, but I just see this as so important. And this is something that you should be aware of when you're applying for coverage. And it's also how your policy triggers work when you're looking to be covered. So most policies ask the question, is the applicant firm or any lawyer aware of any fact, circumstance, or situation that might be expected to result in any claim? Again, you answer this truthfully. And if you flip to the next slide, this is why you answer it, because when you go to potential claims, so all of these malpractice policies cover actual claims, and claims are defined as a demand for money or instituting a lawsuit. So that's really what a claim is. But potential claims, they don't necessarily have to be a lawsuit. They don't have to be a demand for money. A potential claim is something that you might be aware of where you say, oh, you know what, I think I missed a deadline. Or, you know what, when I was in that deposition, I failed to ask a question about proximate liability. Those are things that you might discover that you made a mistake, but there's no claim yet. You should report those early, because what happens is attorneys like April, who are defending insureds, can really get into that and defend and mitigate those situations early. So don't be afraid to report potential claims. And if you're switching carriers, I think the conclusion is, report your potential claim to your current carrier and also disclose it to the carrier that you would be applying for insurance for your upcoming term. So just make sure you report them. All right, avoiding claims. Daniel, I know you do a good job at this. So I'm going to turn this over to you to kind of go through what you do running your own firm and things that you do in your practice that you can share with all the attorneys on this call about how to avoid being in claim situations.
Sure. I always like to joke and I say, I think client management it almost turns into you being your own attorney, right? And really turning your attorney hat on to represent yourself, right? Which isn't the smartest thing to do if you ever have a malpractice claim against you, right? But in my firm, what I realized early on is that a lot of our complaints had to do with communication of some kind not happening, right? And these were just internal client complaints that I thought, oh, this could turn into something, some kind of disciplinary action, or at least just even a filing, which is already a burdensome task to respond to and things like that. And so at my firm, we started putting together a lot of fun things. Like we have a client screening process that allows individuals to automatically upload some information, some of their contact information before a consultation has even happened into our system so that we can run a soft conflicts check before our consultations happen. And that allows me to already see if we have a conflict or a potential conflict. And then, of course, during those screening calls, making sure that you do check for conflict so that you don't run into that issue later on. My engagement letters are so important, but specifically the scope of representation. And I think sometimes our clients do hire us to do this very broad scope, right? In cases at my firm, it usually is a divorce, right? And so how do you write the scope of that out? I have taken the approach that I let clients know that I will specifically help them for their specific case. And I write down the case number in the engagement letter. And then I specifically include a section of my engagement letter that says items not within the scope of our representation. And I bullet point them in the most simplest of terms. What is it that the client pays for and is not paying for? Or what is it that I have said I'm going to do, but specifically what I've said I'm not going to do? So that if that comes up, well, it was very, very clear what was not within the scope, right? So it's like you have the broad piece. This is what I'm helping you with. This is what I'm most certainly not helping you with. And then I can't help but say the biggest thing is like communication. I've read a lot of articles on why people sue each other. And a big part of it is that they say that we won't sue someone that we actually like, right? And so if you're communicating with your client in a manner that their expectations, that they have the expectation of, I think people are going to like you. And so at my firm, we've taken the approach that in our engagement letter, we have what the client agrees our communication procedures are going to be. But then we've taken the approach of proactively scheduling calls with our clients and requiring clients to schedule calls with us. So I always tell my clients that when you work with my law firm, it's like going to the doctors. Like I've never walked into my doctor's office and said, hey, see me. I've done that at urgent care, but that's different. And so essentially all of my clients know that when they call in, they'll be scheduling a call with me. And then that call will happen tomorrow or sometime after that. But the client is always aware that I'm never receiving those complaints that communication is a problem anymore. And I also write some language in my engagement letter about responding to emails. And then I have separate of my engagement letter, a little welcome guide that I give my clients that also kind of says like, hey, emails that are too long sometimes don't get responded to because they deserve phone calls, right? And so I tell them to have that in mind too, that phone calls are my preferred method of communication with the clients because I feel like we can answer more in one of those. And then when it comes to deadlines, I use a practice software where we're constantly adding tasks to it, and reminders, and actually using it. I work at a co-working space with other attorneys, and it's really interesting to see just how many people have a practice software that they don't utilize. And I'm always like, well, what is the point of it? And I think the big thing there is that if you're utilizing the software, if you're getting into the habits, you're not going to miss deadlines, or maybe you will miss a deadline, but it's not something because you didn't note it, right? It may be something you overlooked later on, but you had the reminder there to help you out. I love this bullet point that we have next, which is like know the law, the area of practice. I will always remember my first year having my law firm. I had a friend call me up, and she had a mechanics lien issue, and she was like, "It's going to be super easy. Just take my case." And I did, and it was it was horrible, because it wasn't the area of law I practice. It took much longer than I needed to. And to be quite honest, I always had this fear that I was going to be committing malpractice because I just didn't know exactly what I was doing in this courtroom, the procedures of that courtroom, the processes that happen. I always say the law is already confusing. And then we as practitioners go before judges who have their own rules, and we're before different tribunals that have their own rules. I think the more you can niche yourself, the less likely you are to commit malpractice in one of these type of ways, right? Of just not knowing a rule that existed out there. I kind of already mentioned the avoiding conflicts of interest. I always try to keep that in the client screening process. And if I do think I have a conflict, I point it out to the client, and I let the client know that I'm going to disclose that conflict to the opposing counsel right away, so that if for some reason they believe that there's a conflict, that maybe I need to withdraw and they need to hire someone else. And then the last one is to not officially sue for fees. And I love to read that in my malpractice questionnaire every year. Is like, do you sue your clients for fees? And I'm like, no. No, I don't, because I know my insurance premium will probably go up, because again, if people like you, they probably won't sue you. Now, I don't know if I sent someone, sued them for fees, I think that they're not going to like me much longer. That is to say that I think as business owners too, that we should be collecting our fees, and we rightfully should receive payment for them. But I think we have to manage that risk, with the risk of being sued and just the headache that comes with that, especially depending on the amount of money that you're owed.
And April, defending these matters, right? And seeing suits for fees, you probably see that very often. And that's the tipping point. That's what usually starts the ball rolling with a malpractice action. So, you see that a lot, and I'm sure you can, comment on that, just how often it is when you see, oh, this was all because the attorney sued for fees.
And, a lot of those cases actually go back to what I had mentioned before, this disappointed expectation. Oh, I don't want to pay you because I didn't get what I wanted. And oh, by the way, if you sue me for those fees, now I'm going to say this was all your fault. I'm going to point out all these things that I perceive that you did wrong, whether those perceptions are true or not, especially in areas such as Daniel's practice, family law cases, because his types of cases, they're very emotional, and somebody might be upset with the situation with their former spouse, and while they can't do anything about their former spouse, some of those feelings just get transferred to the attorney. Oh, this did not come out well because you didn't do your job, even though we as attorneys do not write case law or statutes, and sometimes what might seem fair does not play out in what the law says is recoverable.
Yeah, there's some tips to, when I talk to attorneys about suing for fees. I remember talking to an attorney and I said, well, don't sue for fees. And he became very angry with me. And he said, how dare you tell me I can't collect money that I'm owed from a client? And he educated me and said, what we'll do is sometimes you wait until the statute of limitations expires for malpractice. And in a lot of states, it's 2 years. And then you can pursue with your fee matters. Or like Daniel said, and Daniel does a good job with this, you clearly put in your engagement letter what your fee structure is, and you're regularly communicating, just like if you're driving in a taxi cab and the meter's running, what you owe on a monthly basis. Don't wait until the case is resolved to send a large bill that would shock them or make them angry. It's nice to get a bill and to bill maybe every 120 days, every 90 days, just so that they know what they're accruing, because sometimes that also aids in settlement too. If you have someone who's like, I've got a winner of a case here and I'm going to dig my heels in, after about, 12 to 18 months of litigation, they see, the bills racking up. Sometimes that actually helps you settle and resolve a case.
Right.
So it's about using that as using that smartly and wisely. Okay, the next slide. So this is something I'm very proud of. This is the relationship that I mentioned with April and Hinshaw. We provide risk management services to all of our insureds, and there's no additional cost to this. And the beauty of it is, first and foremost, this is confidential. So any attorneys that are insureds with us who have risk management type questions or pre-claims assist questions, who go to Hinshaw, that's not a strike against them. It's not considered a claim. It's not considered something that goes into the underwriting file. And Hinshaw has built, first of all, an amazing risk management library with sample engagement letters, disengagement letters. There's 4 hours of consultation that's included to discuss matters. And we also provide complimentary continuing education through their library. This is something that, it's such a nice benefit to have. And again, like I said, we're very proud to partner with Hinshaw and April on this extra perk that you get as a policyholder.
Yeah, so I'd love to dig in a little deeper about, what you get when you have Berkeley Select as your carrier. As Al stated, we actually at Hinshaw, so we have a very large professional responsibility team, and that includes legal malpractice claims. So as Al mentioned, we have a database of forms that you can use to reduce your risk. So you heard Daniel talking a little bit ago about his engagement letter. Says specifically what he does cover and what he doesn't cover. That's often your first line of defense against a legal malpractice claim. So for instance, in the past, I've defended claims where a business attorney was retained to essentially remodel the business entities. But there was a CPA separately that came in and gave advice on tax consequences. Now, our attorney, unfortunately, did not have any limitations in his engagement agreement. Had he had access to this type of service, he could have gone and gotten something that said, I will do the business entities part of the claim, but not giving tax advice. Unfortunately, there was no limitation. So when the tax advice that was given by the CPA was wrong, the client came after both of them, even though our client had absolutely no experience in tax at all. So those are some things that you can just go to the website and pull. You don't have to reinvent the wheel. As Al mentioned, we provide CLEs. This is going to be on different hot topics in legal ethics. So, you can also get some of those CLE credits knocked out as part of the services that are provided. But one of the things that we're most proud about is our legal ethics hotline. So what does that mean? As part of your policy, you can call the legal ethics hotline. We respond to the extent that we can to the call within 24 hours. So if something happens and you're scared that you might be facing a legal malpractice claim or a bar complaint, you can call an attorney who specializes in this area of law. We field a wide variety of questions, from lawyer advertising to conflicts of interest. Certainly, we're there to help provide conflicts waivers. And I would say probably one of the recurring calls that we get is someone missed a deadline. So if you miss a deadline, there are certain things that you kind of need to have figured out before you try to fix it. So for instance, what do you tell your client about the deadline based on model rule 1.4? And every state has its own communications rule. We tend to go with the model rules because at least in these presentations, because they're going to be pretty similar. There's variation from state to state. But then the question is, well, can you continue representing that client in light of the fact that you potentially have a conflict? If the missed deadline is does not turn out favorably, you can't get out of an argument that you didn't miss the deadline, or you can't get the court to grant you relief, then potentially there's going to be a lawsuit. So you have to think about how are you going to get that conflict addressed? We help with conflict waivers when we get those calls. I've done that several times where, I've helped a client develop a conflict waiver so that they can go in and fix that mistake before it turns into an actual claim. And I think one of the most important things to know, kind of as Al had mentioned, is that when you call our hotline, we run a conflicts check because we essentially enter into an attorney-client relationship with the person on the other end of that hotline. We become your lawyer, but everything we do is confidential. You're assigned a number, it's anonymous. And so, that you can have some peace of mind when calling the hotline. And we can work on a variety of different issues. Sorry to, I think I might be belaboring this point a little bit. But anything I didn't cover, Al?
No, that's perfect.
Yeah.
Well, let's get into what lawyers do to get themselves into trouble that we have not already discussed. So the American Bar Association has a committee on lawyers' professional liability, and they do a claims study. And most of the carriers that write this line of business participate in that claim study, and they're sharing data. You don't know what carrier is reporting what, but it is a compendium of all of their data and experience in these lines. And there are a few things that we can share with you that we've learned through the ABA that can help you if you are involved in one of these areas of practice. So if you go to the next slide, April, if you want to talk about some of these areas of practice, these tend to be the most frequent areas of practice that result in claims according to the ABA study. So some of them are obvious, right? I mean, personal injury is obvious based on the volume of cases that a personal injury lawyer carries, the deadlines, the strict adherence to deadlines, missing statutes of limitations, such as that. But if you want to take us through some of these and just discuss some of the high points from your practice and pitfalls that if you're in these practice areas, what you can expect.
Yeah, so personal injury, one of the big things is statute of limitations on personal injury, because it's not always clear. You can have things like the discovery rule that might apply, and making sure that the statute of limitations on the personal injury claims are protected. If it's a medical malpractice, that's going to be different than the injury claim, for instance. In many states have different statute of limitations. Family law, I think what we see in family law is, as I explained before, you have these are often some of the most contentious cases that you have and people are very personally invested. Same with real estate. Generally, real estate purchases are some of the biggest purchases people will make in their lifetime. Commercial real estate as well. Estate trust and probate. These are some of the claims where when a will is written and then it's probated, the will is written many years ago, and people in hindsight say, well, no, this was a mistake, that was a mistake. And so, in many states, there are laws that limit who can recover and under what circumstances. For instance, in Wisconsin, you have to demonstrate that the testator's intent was clearly thwarted. That's a high bar. But you do have, again, that's a personal area of the law. Similar with collections and bankruptcies. I think these are all areas where people are really personally invested in these claims. And, perhaps that's one of the reasons why we see those claims jump up a little more frequently. Now, we do have at the bottom immigration law. Now, the ABA did not list immigration law as one of the top areas where claims are made. But notably, what the ABA study showed was immigration claims, they have grown exponentially recently. And, why is that? Well, one of the reasons for that is that there's been significant changes in US policy. Another reason is increased volume. Another reason is sort of what Daniel was getting at before, and that is this idea of dabbling. One of the worst things a lawyer can do is dabble in an area of law that they're just not familiar with. Because as Daniel had mentioned, like, hey, I had this claim, and I was just filled with anxiety because you don't know what you don't know. But that's the reason why lawyers are hired as trusted advisors, because we actually know the way to establish defenses or liability if you're on the plaintiff side. And so if you start dabbling in an area of law that you don't know and you don't have anybody in your office who can guide you through, that's where you can really start making some of those big mistakes. And that goes to the rule of competence. Immigration also, we've started to see frequently claims that involve a loss of liberty. So, for instance, in criminal law where there's a potential immigration component to it. So I think those are kind of like some of the hot areas that the ABA study kind of touched upon.
Yep, they sure are. Thank you for that. And if you want to flip to the next one, Daniel, if you want to just go through some of the practice areas that the ABA has published, these are common errors. So, we already said failure to know the law. We already said failure to calendar properly, missed statutes limitations. But if you want to maybe discuss a few of those, and we could kind of close this segment before we get into a little bit about Berkeley Select.
Sure. I think the big thing here, the one that stands out to me the most is like failure to follow your client's instructions, right? And I feel like as a practitioner, that is where we kind of get to guide our client, and then they get to actually make a decision. And I think sometimes we forget that they're the decision maker at the end of the day. I don't share with it a lot. I don't dabble in this area of law, but I actually practice it. But I do practice real estate transactions. And I have told people not to buy homes before. And and if it were up to me, I'd cancel this contract and they'd be out shopping for a new house, right? Because they're about to spend $20,000 on a new roof, or, a furnace is about to blow out that is going to cost them $10,000, right? But at the end of the day, it's up to them to make that decision. And so while I can tell them like, hey, this is how I would advise you, we should cancel this contract, right? At the end of the day, they'll say, no, I still want to proceed with this house. And I'll follow up with an email saying, well, it was a pleasure advising you not to do this thing that you just said you're going to do anyways. Or just this week alone, I had a client tell me that he wanted all of these changes to a marital settlement agreement, but that he wanted the case also done right away. And I said, well, I can't guarantee that I can finish this in a week, because you want all these changes. And he said, okay, fine. Then I don't want any of the changes. And I was like, wait, I'm not advising you not to make these changes either, but that was his decision. And again, followed up with an email, followed his instruction. He wants to sign this document, he can sign it, right? So, yeah, I'll just pause right there.
So, oh, sorry. Just to follow up on what Daniel said, and I think he made a great point. Ultimately, it is the client's decision. But this is one of those things that you want to have documented in writing. So, for instance, if it's, if there's a potential that a real estate transaction could be problematic down the road, you have the conversation with the client, and then you do the notation to the file. Make sure that the file reflects that you advised them of the risks, and that the path was chosen with the client to proceed forward despite those risks. And so that way, you can prevent a legal malpractice claim coming up down the road about the risks that you disclosed, because ultimately it is, you may be the attorney, you may know the law, you may know better than them, but it is your client's decision as to what to do materially in a case. And so all you can do is advise them of the risks, but make sure that once you've advised them of the risks, that you document that those risks have been raised and that the decision was made to go forward anyway. So that way, when a legal malpractice claim is brought, all you have to do is show this email and really the claim can't go anywhere.
Great. So let me take a minute just to kind of describe who we are, what we do, what our position in the marketplace is, kind of what our appetite is, and then we'll reserve the last 5 minutes for questions. There will be a survey that will be sent when everyone hangs up today. We would appreciate you completing that, basically telling us about this presentation and asking a few questions about your purchasing habits for malpractice insurance. But we have an in-house claims department. We have all specialists. We have a lot of attorneys that work here in our claims department. 30 years of experience doing this. If you flip to the next slide, we're part of a larger organization, WRB. It's on the NYSE. We're rated excellent by AM Best. We have the largest financial size category. We're backed by a very strong company with great financial and solid financial footing. And if you go to 2 slides, just our target appetite, we'll write solos, we'll write larger law firms. We're very open in terms of our appetite. We're available in all 50 states. So new law firms, established law firms, we can handle them all. We have experience with all of the areas of practice, even the new and emerging ones. So we'd like to thank you for participating. We've got 5 minutes left for questions. So if there are questions, we'd love to try to answer them for you.